Good morning, everyone, and welcome to our webinar on what is the trust and when should I use one. My name is Claire Spinks and I am Head of Tax Technical and Development for the Fry Group. When we consider what topics we should cover in our webinar series, we want to focus on the areas that we think will have most relevance for our client base. We feel that trusts are one of the single most powerful estate and financial planning tools, but are also the least understood. There is a huge misconception that trusts are for extremely wealthy, and so many are unaware of the value a trust can have when it comes to managing your assets. Today, our panel of in-house experts aims to dispel the ambiguity surrounding trusts and provide you with a concise understanding of why a trust can be effective, when you should use one, and what you might want to include within that trust. So a little bit of housekeeping before we get started. We expect the webinar to last somewhere between an hour and 15 minutes. And during that time, we would encourage our audience to enter questions in the Q&A box as they come up, and we will do our very best to answer these for you at the end. If you miss any part of the webinar, that is no problem at all. This should be available online in the next few days. And in addition, if you think it might be helpful, you can always request a copy of our slides. So I will introduce our first panel member, Peter Webb. Peter is the Head of Tax Advisory for the Fry Group and may be familiar to many of you. Peter is often heavily involved in the tax aspects of financial planning and understands the intricacies of tax planning with a trust. Hi, Peter.
Hi, thank you, Claire. So at the end of our presentation, you're going to have plenty of questions for us. But before we really get started, I actually have a question for you. And that question is going to pop up on your screens around about now. And the question I have is, what would you consider using a trust for? So to save tax, to protect an asset for a specific beneficiary or beneficiaries, to maintain confidentiality of ownership of a sensitive asset, or all of the above. So I'm just going to give you a moment or two to pop your answer into the polling question. Oh, I can see lots and lots of you are voting. I think there's plenty of voting still going on, so we'll keep the poll open for just a little bit longer. Okay, I think the voting's slowing down a little bit now, so I think we'll probably close the poll there and just see how we did. Okay, oh goodness me. To save tax, 22% of you. To protect an asset for a specific beneficiary or beneficiaries, 31% of you. Maintain confidentiality of ownership, 1% of you for that. All of the above, nearly half of you. As we go through the presentation, you'll see there are lots and lots of different reasons why you would actually settle a trust. So over the next few minutes, I'm going to try my best to explain what a trust is. There are complicated legal definitions of what a trust is, so I'm going to try my best to put that in friendlier terms for you. I like to think of a trust as a treasure chest. Someone puts assets, perhaps some money, into this treasure chest, and they give the keys to someone else, perhaps together with a letter that explains when the key holder should take money out of the treasure chest and who they should give that money to. And that, in essence, describes what a trust is. When we start talking about trusts, we then start using jargon, special words to describe what is going on. And you're going to hear a lot today about trustees, beneficiaries, settlers. So what do all of these words mean? I'm going to go back to our treasure chest analogy. The person who puts the assets, for example, some money, into our treasure chest, now they are known as the settler. They are the person who puts the money into the trust, the asset into the trust. The person who holds the key to the treasure chest is the trustee. And there can be more than one key holder, more than one trustee. The settler will have written a letter to the key holders, the trustees, to tell them who they should give the money in the treasure chest in the trust to. And the people who are named in the letter who are entitled to receive money from the treasure chest, the trust, are the beneficiaries. They can benefit from what has been put into the trust. So the settler is the person who puts the money into the trust. The trustees are the people who are now responsible for what has been put into the trust. The beneficiaries are the people who can receive money and assets from the trust. And it's worth mentioning the role of a protector. A protector is somebody the settler would nominate to ensure the trustees do their job properly, to ensure they do act in accordance with the instructions the settler has actually given them. So why would you settle a trust? There are many, many reasons why you'd want to put an asset into a trust. I'm just going to pick up on one reason as an example, and we're going to talk about other reasons as we go through the webinar today. So your friendly tax advisor tells you the best way to reduce your inheritance tax bill is to give £300,000 to your children. And you need to do it now because in your circumstances, you need to survive 7 years from making that gift for the plan to reduce your tax bill to work. But your children are teenagers. Do you really want to give them £300,000? So what you could do instead is to gift £300,000 into a trust with instructions to pass the money on to your children when they're older and maybe better able to handle receiving such a large sum of money. Now, by gifting into the trust rather than making a direct gift to your children and making sure you can't use the money in the trust, you've started the clock running on that 7 years you need to survive to make this work to reduce your tax bill, but you've also been able to protect your children from receiving too much money when perhaps they are too young to use that money wisely. So how do you create a trust? There are various ducks you're going to need to line up into a very neat row in order to create a trust. A professional advisor is going to help you understand what you need to do. You can create a trust in your lifetime or in your will when you pass away. In your lifetime, you create a trust with a trust deed. In our simple example that we've been using about the treasure chest, that trust deed perhaps is the letter that is given to the key holder of our treasure chest. So that trust deed or your will need to be carefully written, and actually amongst much else, it's going to need to ensure that it does indeed create a trust. The beneficiaries of the trust and when they can receive money from the trust and how they can receive money from the trust, that needs to be clearly defined as well. You need to say who the trustees, who the key holders actually are. Another thing you need to mention is how long this trust is actually going to run for. There are many different types of trust that we see. I'm thinking of trusts for vulnerable beneficiaries. Life interest trusts are some that we see. I'm not going to talk through all the possible different types of trust you could use. I'm going to pick one which is perhaps the most common that we see, and we call this a discretionary trust. So going back to our original example of this person who's locking away assets in a treasure chest, and then he gives the key to another person, together with a letter explaining when he should unlock the treasure chest and give money to the people named in the letter. So in real life, that letter could say things like, when my child wants to purchase their first house, you should release funds from the trust to enable them to do that. Those kinds of words would indicate that this is a discretionary trust. The trustees, their key holders, they use their discretion to release funds to the beneficiaries when, in their judgment, and guided by the wishes of the settler of the trust, it is the right time to do so. So that describes a discretionary trust. Goodness me, how are trusts taxed? So now we move on to one of the more complex areas when advising on trusts. So bear in mind today, we're only going to talk about UK tax. The UK tax the trust pays is going to depend on a lot of different things. Things we need to consider are the UK tax residence and UK domicile status of the person who gifted the assets into the trust, who is able to benefit from the trust, and the UK tax residence and UK domicile statuses of those people who are able to benefit from the trust. You may even need to look at the UK tax residence status of the trustees. You need to look at the types of assets which are actually in the trust. It could be properties, shares, cash, maybe some clever structured investments. And you need to look at where those assets in the trust are actually cited. Which jurisdiction are they in? So you're going to want to speak to somebody who specializes in how trusts are taxed to sort out the tax side of things for you. Well, that's a very brief introduction, but I hope that's given you some insight into the basics of what a trust is. And at this point, I'm going to hand back to Claire.
Thank you, Peter. That is indeed very helpful. So at this point, I'd like to bring in two of our other colleagues, Hugh and Shannon. Hugh heads up our Singapore office and has many years of experience providing financial advice to his clients. He is highly experienced in understanding what part a trust can play when achieving your key financial objectives. Shannon, a trust executive from our Trust and Estates department, specialises in assisting families daily in the running and the administration of trusts. Good morning to you both.
Hi, Claire.
Morning.
Hi. So, Hugh, a question first for you. What role does a trust have in reducing how much inheritance tax you can pay?
Yeah, well, the answer to that is a substantial one. When we're discussing estate planning or inheritance tax mitigation with our clients, generally we'll cover 4 areas. And they're firstly, erosion of your taxable estate by spending some of your assets during your retirement, insuring against an inheritance tax liability, making lifetime gifts to either individuals or trusts, and lastly, making use of all the reliefs and exemptions that are available to you under the current UK tax code. Now, there aren't any other ways of mitigating an inheritance tax liability, so everyone's strategy will involve one or more of those areas, and for different individuals, we'll have a different blend of those solutions. So, if you're not going to spend a good proportion of your asset base during your retirement, and you either don't want to or you can't insure against the liability, then you have to consider some gifting. To summarize, gifting into trust enables you to substantially over time reduce the value of your taxable estate, but crucially retain control over who ultimately benefits from the gift. And a trust could even allow you ongoing access to income or your original capital.
Great, thank you. I think that's given us a better indication of the scenarios that might help. Hugh, also in your experience, what are the most common types of trusts that you see help our clients with financial planning?
Yeah, so I'm going to mention 3 trusts, 3 differing trust solutions, and they're all suitable for individuals who are UK domicile. And I believe Peter will talk about non-domiciles a little bit later on. On those 3 solutions, now for someone who would like an income for life from the gift that they make into trust, but don't need any access to capital, then we can access an arrangement that's called a discounted gift trust. Now, as the name would suggest, that would give our individual a substantial discount on the value of the gift that they're making into the trust on day one. It would give them complete certainty that the whole trust asset was outside of their estate after 7 years. And really importantly, it would pay them an income from the trust for their whole life. If, on the other hand, you don't need access to your capital, on the other hand, if you need access to your capital, but you're prepared to forego the growth on the asset that you're putting into a trust, then you can access something called a loan trust. Now, a loan trust is also commonly called a freezer trust because it effectively freezes the inheritance tax liability on the asset that is sat in the trust. All investment growth is immediately outside of your estate from day one and held in trust for your beneficiaries. If neither of those things is required, so you don't need an income or capital, then you can make a direct gift straight into a discretionary trust or a bare trust. But it's important to take advice on the extent of the gift that you're going to make, particularly into a discretionary trust. And that's because there are inheritance tax charges on entry into discretionary trusts if you contribute an amount into the trust that's in excess of the IHT nil rate band that is available to you at the time that you make the gift into it. Final thing I'm going to say there is that type of trust that I've just described, bare and discretionary, they are used for inheritance tax mitigation, but they're also used where there is not a tax motivation to put assets into the trust. So where there's more of an asset protection motivation from the trust perspective, that's also typically where bare and discretionary trusts are used.
Okay, fantastic. Thanks for you. So, Peter, what are the circumstances where you see a use of a trust being most beneficial?
Thank you, Claire. I think one of the most compelling reasons to use a trust is to protect assets from a 40% UK inheritance tax charge. And I think one of the most effective tools we have in our arsenal for that is what we call an excluded property trust. And this is for somebody who is non-UK domicile of origin, so a non-UK domicile, and perhaps they're becoming UK tax resident. Now, a non-UK domicile, their overseas assets are not within the charge of that 40% UK inheritance tax. But once that non-UK domicile has been resident in the UK, that non-domicile status has a time limit and they will become UK domiciled. And at that point, their worldwide assets are pooled within that 40% tax charge. So what you can do, what the non-UK domicile can do, before they become UK domiciled, they can protect overseas assets into an excluded property trust. Those assets are then protected from that 40% UK inheritance tax charge, and that protection will endure even past the point where they've become deemed to be UK domiciled or domiciled by choice. So I think that is likely, in my experience, the most effective trust that we see used for our clients.
Absolutely, Peter. I would completely agree. Shannon, would you have anything to add to that?
So actually, I'll go back to basics, and I think that it's becoming more and more common to use a trust just simply because the beneficiaries are unable to manage their finances themselves, and the settler's just concerned that the funds would be spent unwisely. So you can create a trust to ensure the funds are only released by the trustees for a specific purpose, for example, a deposit on a property or other ways which is deemed in their eyes more sensible. If the funds were given to beneficiaries outright, then obviously they can utilise those funds however they wish. Essentially, the settler or indeed the trustee would have no say. So having a trust is a way of protecting those funds for the next generation or other beneficiaries without them having direct ownership over them.
Okay, great. Thank you. Hugh, are you able to give us a real life example of how trust planning has particularly helped one of your financial planning clients?
Yeah, so I'm thinking about a client who is he's a UK domicile. He's resident here in Singapore, and he's got married for a second time, but he has children from his first marriage. Now, we identified for this individual that potentially he had £1 million sterling's worth of assets that he could put into a trust, but if he were to do so, then he'd require an income from the trust asset. So for this particular individual, we set up a discounted gift trust, which meant that our client could take an income of 4% per annum of the value of the trust asset every year, indexed at 2%, so with a measure of inflation protection. Our client got 50% of the trust asset outside of their estate on day one, and the other 50% will be outside of their estate in 7 years' time. It's actually been in place for 3 years now, so in another 4 years' time, the trust asset will be completely outside of his estate. So there's an income source there for our client and his wife during their lifetime, and the remaining capital, once they've passed away, is in trust for their for our client's children from his first marriage. So essentially what we've done is three things. The trust has provided a handy solution for inheritance tax mitigation. We've sorted out our client's income needs in retirement, and we've also solved that issue that he had around succession planning and control ongoing.
Okay, wonderful. Shannon, just picking up on something you said earlier about, trust having different sort of functions. One of the types of trust that we see is for vulnerable beneficiaries. Could you tell us a little bit more about those types of trusts?
Yes, so those trusts can either be set up so they take effect on death or during a person's lifetime. So they're typically set up where there is a child under the age of 18 whose parent or parents have passed away, a disabled person, or someone who's unable to manage the finances. So they'd offer possible income tax and CGT advantages, as well as certain inheritance tax, for example, no 10 yearly charges. The two options we would generally look at is either discretionary trust, where the trustees have the most flexibility, and Peter's already discussed this earlier. So the trustees would have discretion when to release funds to those beneficiaries. Or a disabled person's trust. So with this, the main advantage is that a trust is a way of ring-fencing assets for that chosen beneficiary, so their means-tested benefits would not be affected. Both types of trust can also protect the beneficiary from the risk of financial abuse if that was a concern. But setting up a trust for a vulnerable beneficiary is very complex, so it needs to be drafted correctly, and I'd suggest professional advice is sought.
Okay, thank you. So Peter, a question for you that I imagine a lot of our audience are wondering. Do you pay tax on the money that you receive from a trust?
Oh, what a good question. You'll see from my comments earlier that taxation of trusts and the taxation of beneficiaries, it depends on a lot of different moving parts. It's going to depend on the nature of the trust. It's going to depend on whether you're receiving income or capital gains from the trust. It's an area of real complexity. And the trust itself may need to pay tax on the amounts that they pay to you. Now, if the trust actually pays tax on the amounts that they pay to you, you're generally able to take credit for the tax the trust has actually paid when you work out your own tax liability. There is no easy answer to the question, but taxes to consider are income tax, capital gains tax, or maybe even inheritance tax, and if there's a property involved, maybe even stamp duty, land tax. So not a neat, concise answer there for you, Claire.
How much reporting is going to be needed on someone's tax return if they've settled or they're a beneficiary of a trust?
Yeah, so again, it's going to depend on the nature of the trust and the income and gains that have been received from the trust. But if you don't already complete UK self-assessment tax returns, then either gifting assets into a trust or benefiting from a trust could draw you into the UK self-assessment tax return regime. In addition, the trust itself may need to register with HM Revenue and Customs, and the trust itself may need to submit its own tax returns, and the trust itself may have its own tax liabilities to pay. But I think trust registration is a really hot topic at the moment. And Shannon, do you have anything you can tell us about trust registration?
Oh, it certainly is at the moment. So I think this is something a lot of lay trustees would not have considered. It's only something that HMRC have been brought into effect recently, and it does include both taxable and non-taxable trusts. The deadline for all existing trusts is actually tomorrow, so the 1st of September 2022. And over the last 12 months, we've been undertaking a massive project here to register all of those where we're appointed as the trustee. But going forward, all trusts that are set up will need to be registered with HMRC within 90 days. HMRC did recently issue guidance confirming there'll be no penalty where there is a first offence of failure to register, or there's a late registration, unless it can be shown that the trustees were deliberately not registering the trust, in which case a £5,000 fee would actually apply per offence as well. It looks as if HMRC will issue a warning letter if they can identify a trust hasn't been registered. And once they've issued the warning letter and it's been ignored, then the penalty will be applied.
Great, thank you. Shannon, what do you see the downsides to using trusts might be?
I would actually say the appointment of trustees, as that can be an extremely difficult decision. If you were to appoint a lay trustee, it would be the complexity and the ongoing administration of the trust. Everyone does have their own lives, so it's quite an extensive role to take on. You also need to trust them implicitly to follow your wishes. And it's important they maintain a good relationship with the beneficiaries, as obviously they're making the decisions. If you appoint a lay trustee, they could obviously pass away, they could be too busy, they cannot cope, or they could lose capacity. That's why a professional perhaps might be more suitable, but then you obviously have to think about the professional fees. It's weighing up the benefits.
Great, thank you. And Hugh, you'll see a different side from a financial planning perspective. What do you see the downside of using a trust might be?
Well, I think I've mentioned two things. Whatever type of trust you're using, there is going to be some loss of control over the asset in favour of the trustees themselves. And trust can be complex. There is an element of complexity that we're trying to cut through today. But I think with regard to both those issues, it's really about understanding properly trusts and trust arrangements, and of course key to doing that is good advice, and one or two of us have already said that today, but you can cut through that complexity by getting the right advice.
Great. And Peter, I suppose lastly from a tax perspective, any downsides from you?
Yeah, I think so. I would agree with Hugh on the complexity. Trusts are a good solution, but they can be a very complex solution to perhaps reduce your tax bill or protect assets for beneficiaries. In the UK, there's a more penal UK tax regime for trusts. And actually using a trust, you might actually pay more in tax on the income and gains that come out of a trust than if the assets were actually held directly. I think also I would mention that once you've settled the assets into a trust, that's actually very, very hard to undo. It may actually be impossible to undo. And it may be the case that you've put that capital completely beyond your reach.
Okay, so I think complexity sort of seems to be a bit of a running theme there. Peter, would you say there are any alternatives that someone might have for protecting assets or potentially saving inheritance tax that doesn't involve a trust?
Yeah, so I think when you look at the alternatives, a really well-written will can be a good starting point when you think about reducing inheritance tax. But I think some of the really simple things that you can do can be very effective. So perhaps rather than gift an asset into a trust, you might want to consider actually, is it right to make an outright gift to your intended beneficiary during your lifetime? You lose control of the asset, but you haven't got the complexity of a trust. I think another thing that you want to consider is perhaps a specialized vehicle, such as a family investment company. And we see these more and more being used. So a family investment company is a special company, and you perhaps have all of your family members as shareholders in the company. And this is a way to manage your family's assets in quite a sensible way, and allows the people who gift the assets into the company to have a lot more control over those assets and a lot more say as to the incoming gains, where they actually go. And a family investment company can certainly help you with inheritance tax too. So I've mentioned that they're a very, very complex piece of advice to give up front to make sure you get your family investment company set up correctly. But I do see those as an alternative to consider besides actually using a trust. Just a final comment, actually, another alternative to using a trust is, what are you going to invest in? Is there an investment that you could make into an asset that would have the same effect of reducing your inheritance tax exposure? So there are investments that you make, hold them for a couple of years, and maybe the value of the investment is then outside of your chargeable estate, that 40% UK inheritance tax charge. And you would speak to a specialist advisor on all of those points.
Okay, fantastic. So Peter, in terms of assets that can go into a trust, is it possible to put a property in trust, say for children?
Oh, goodness me. I'm assuming this is a UK property. Generally, you do not have an immediate charge to capital gains tax on gifting property to a trust if the property is perhaps your main residence, or if the gift into the trust is what we call a chargeable lifetime transfer, immediately chargeable to inheritance tax. The capital gains tax with that chargeable lifetime transfer can then be deferred, but that capital gain perhaps will be payable down the line. So I think if the property is not mortgaged, then gifting the property into a trust would generally not provoke a charge to stamp duty land tax. But if the property is mortgaged, that is something to watch. It's another tax that you need to be aware of. Depending on the value of the property you're gifting into the trust and perhaps the previous gifts you've made, there could be this chargeable lifetime transfer, this immediate charge to inheritance tax at 20% above your available inheritance tax nil rate band. In addition, when we think about inheritance tax, there could be what we call 10 yearly inheritance tax charges. Now, these are generally smaller inheritance tax charges, but they are there. There could be further inheritance tax charges when the trust gives the property perhaps to your children at the right time. So the property comes out of the trust and then into the ownership of your children. That could provoke an inheritance tax charge. I think a really important point to make here is that if you're gifting the property into the trust, it's really, really important that you don't retain any benefit in that property. If you do retain some rights over that property, some benefit in that property, the value of that property could in fact remain within your inheritance tax estate. Income tax, maybe we think about income tax. Any income earned by the property in this trust, that's going to be charged to income tax at a flat rate of 45% for the trustees in the first instance. But perhaps that income gets passed out to the beneficiaries, and the beneficiaries can then reclaim some of that tax that's being repaid, some of that tax that's being paid, I beg your pardon, by the trustees. I think in summary, if you're able to avoid an immediate charge to inheritance tax, and bearing in mind the ongoing costs for administration and compliance with HM revenue, such as trust tax returns, then holding a property in a trust could be helpful, particularly perhaps when you want to protect the property for perhaps children later in their life.
Thanks, Peter. And I think sometimes that's something I've seen quite popular with, university towns, families may wanting to sort of hold a property for use of future generations. So Shannon, probate, the process by which assets are passed out to the beneficiaries after somebody's death, can of course be a really lengthy process. Do you think trusts can help at all sort of speed up that process of distributing the assets?
Yeah, so holding assets in trust can certainly speed up the process of passing funds into the hands of the beneficiaries. The reason for this is they're not held by the deceased, they're actually held by the trustees. So usually funds are released quicker from a trust than from an estate because the grant of probate is required. Now in the UK, that's taking months and months at the moment. So instead, sight of the death certificate would suffice for the trustees to proceed with the distribution of those assets. Many clients have created trusts to help with the inheritance tax liability on death as well, because obviously it will be released quicker. And then also if they want the beneficiaries to have funds sooner than they would with probate. I wouldn't recommend creating a trust purely for that purpose due to the costs and the possible tax consequences. But if you were creating a trust for another reason, then this would certainly be an advantage.
Okay, great. So Shannon, do you have any examples of when it might be helpful to include the provisions in a will to create a trust when someone passes away?
Yeah, so perhaps the most obvious example is where there's a contingency. So there's an interest that doesn't take effect until a condition has been met. So that could be the beneficiary attaining a certain age, for example, 21 or 25. Or a discretionary trust can be used if you don't know how you wish to benefit. For instance, you're unsure on the proportions. It's a very useful way to protect a beneficiary going through a divorce, subject to bankruptcy proceedings, or it's useful if the beneficiary is a spendthrift or unable to cope. This type of trust provides the trustees with the greatest flexibility, and usually you would prepare a letter of wishes alongside the will to provide the trustees with guidance. You could also use a life interest, which is useful if you have children from a previous relationship or have remarried. So you can give your surviving partner or spouse a life interest over your assets, meaning that after your death, they can benefit from those assets, including the income, until they eventually pass away, at which point the assets are passed back to your children or your other nominated beneficiaries. In other words, the capital is protected, and it's a way of ensuring your children ultimately benefit from your estate. I think a great example would be a well-known Hollywood star, Patrick Swayze. He cut out his family in his will 7 weeks before his passing, which prompted a legal challenge from his family that his wife unduly influenced him. I think his estate was worth around $40 million, so they felt that they deserved a piece of the pie. A trust would have been a great way of including the estate so that they could have avoided those problems and the legal actions, and both the wife and family could have benefited.
Brilliant, thank you. And thank you all. I think those questions have been really helpful. And hopefully our audience has got a much sort of better understanding of how we see trusts every day. Just now going to the audience questions, because we've had a lot of them during the time that we've been speaking. Shannon, I think probably this one is best for you. Frederick has asked, how do we handle having beneficiaries of a UK trust living in another country?
So this might surprise people actually, but it is handled relatively similarly to those that are resident in the UK. We would just do additional identification checks. So we would ask for additional piece, for example. The way we would open up a trust bank account, again, it would just be additional checks. The bankruptcy searches would be different depending on what country they live in, but it doesn't necessarily mean it's harder for us to pay beneficiaries to those that are non-UK resident. We would also look at the income tax, and we would pass a R185, which is another form, to a beneficiary for passing on to their own tax advisor in that country. Then they would need to seek advice out there. Okay, great, thank you. So Peter, you've talked earlier about UK trusts and holding property. Paul has asked if there is any benefits from putting a UK property into an offshore trust.
Okay, so generally the value of UK property is not going to be sheltered from UK inheritance tax simply by using an offshore trust or indeed an offshore company even. But you may be able to shelter the value of the property from UK inheritance tax by holding the property in the trust, but only if you're completely excluded from being able to benefit from the property. So perhaps you have put the property into a trust for your intended beneficiaries, for your children. And that's actually where that kind of trust planning would work. But simply holding a UK property in an offshore trust doesn't in and of itself exclude that property from UK inheritance tax. I'm going to take a bit of a diversion because I think a company is kind of an interesting route to explore. And companies can, in some circumstances, give you a bit more flexibility than a trust. Now, you may not be able to completely exclude the value of your UK property from UK inheritance tax by holding it in a company, but what you may be able to do over time is perhaps have different family members who are shareholders in the company, and perhaps over time some of the wealth that's represented by that property could be passed, for example, to the next generation, perhaps by in increments giving shares to children, or perhaps structuring the shares in such a way that future growth in value of that property would actually arise in the hands of children rather than you. Now, there are many different tax considerations around using that kind of company, and indeed, of course, using trusts. So you should certainly speak to a specialist advisor to consider what your options actually are.
Okay, great. Thanks, Peter. So Shannon, again, on the lines of having sort of non-UK trusts or beneficiaries, if a trust has been created in the UK, is it recognised and is it valid worldwide, or is there any special actions that would be needed?
Okay, so it entirely depends on the country in question. Some countries do and some countries don't, unfortunately. We can only advise under English law. So either way, we would advise clients that they would need to seek separate advice in that jurisdiction to see whether it would be accepted. They should also seek advice to see whether there'd be any adverse tax consequences of setting up a trust here.
Okay, great. Hugh, something that we see, I think, really commonly, Rachel would like to understand if a trust can be used to hold funds intended for a child's education.
Yeah, I mean, the answer to that is relatively simple, yes. And I would argue that a trust is a pretty efficient vehicle for holding those sorts of assets. Ideally, you wouldn't want large amounts of capital in the hands of a minor. And also that kind of educational need is one which is served quite well by making regular distributions out of the trust. So yeah, absolutely, we see that fairly frequently.
Okay, great. Shannon, you talked about life interest trusts earlier, and those, of course, maybe be included within a will. Pat has asked how that might work in practice for someone.
Okay, so if it's set up in a will, it's important to make sure that you hold the property as tenants in common. If you hold it as joint tenants, then essentially the trust won't work because it will pass via survivorship. So what you would do is set up 50%, well, your share in the property would pass into a trust. So your surviving spouse or partner could remain living in the property for the remainder of their life, or they could actually downsize. But in that instance, they would need to consult with the appointed trustees. So again, that's going back to the fact they need to have a good relationship. And then once the surviving spouse dies, the asset or the property would pass back to the nominated beneficiaries. So it's a way of ensuring the capital is protected.
Okay, thank you. And Shannon, actually, another question for you. In terms of your experience with looking at trust deeds, do there tend to be specific ages that perhaps parents or grandparents may allow children that are beneficiaries of trusts to have more access to the funds or capital?
So within a trust deed itself that's set up in someone's lifetime, normally you'd name the beneficiaries, but if you set it up in a will, so if, for example, it's you're a parent or grandparent, then you would stipulate an age if you felt that 18 would be inappropriate. So then you could state, for example, 25 or even 30, and then the same would apply to grandchildren. You can stipulate an age for them as well.
Fantastic. Peter, going back to the sort of taxation side of trusts, someone has asked about being UK resident as a non-UK domiciled individual and how long they would need to be resident in the UK for before they were considered UK domiciled.
Yeah, that's a great question. So under the new deemed domicile rules, once you've been UK tax resident for any part of 15 out of the last 20 UK tax years, you are then deemed to be UK domiciled for all tax purposes. So that means that your worldwide income and gains are fully charged to UK tax, and your worldwide assets, everything you have anywhere in the world, is then pulled to within that UK inheritance tax net. However, a word of caution, that's the absolute outer limit on how long you can remain non-UK domiciled. If it's absolutely clear you've chosen the UK as your permanent home, and there are no circumstances where you're ever going to leave the UK again, it could be possible that you become deemed to be UK domiciled by choice, perhaps much earlier than 15 out of 20 years. So again, do speak to the professionals about this. Speak to somebody who's experienced in advising non-UK domiciles. There are bits and pieces that you can do to protect that really valuable non-UK domicile status for a little bit longer, perhaps.
Great, fantastic, thank you. So Hugh, Miranda has asked about the setting up of a trust and has asked if there is a minimum amount that we would warrant setting up a trust.
I think you'd be surprised by that. You know, the actual sort of minimum that we would recommend would be relatively low. The reason for that is because on the whole we can access an off-the-shelf trust at a reasonably low cost, and sometimes at a cost that's actually no higher than the cost of investing a normal portfolio held by an individual. I think the other thing that I would say there though is if we have a slightly more complex trust, or perhaps we have some slightly more esoteric assets sat within the trust, you know, potentially there we might be looking at a bespoke trust deed, and then the cost of setting up and running that particular type of trust is going to be significantly higher, and then I think we would be looking at a higher entry level. But if you're investing fairly non-esoteric assets, then really the kind of investment minimums can be pretty low.
Okay, and what about the timing of setting up a trust? Is it necessary that someone that perhaps isn't living in the UK right now would set that trust up before they became UK tax resident, in your view, from a financial planning one?
Yeah, from a financial planning point of view, yeah, a UK domicile, I wouldn't have any particular issues about them, you know, setting up a trust in Singapore, you know, whilst they were resident in Singapore, sorry, or resident offshore. For a non-domicile, you know, who's perhaps thinking about setting up the sort of trust that keeps their non-UK assets outside the scope of UK inheritance tax, you know, we would, I think, you know, probably me and Peter would counsel that sort of trust planning needs to happen before there is any chance that non-domicile individual could be construed as becoming UK domicile in any way.
Okay, great. Shannon, again, in your experience, what is the role and the duties if someone became a trustee? I imagine a lay trustee, and is there any risk to them from doing that?
I mean, yes, there's definitely a risk, and then it's a very extensive role. It depends when you're setting up the trust and how long you're setting up the trust for, but that could, you know, go on for years and years. You know, if it's a minor and you've set up the trust that they inherit when they're 25, and when you pass away, they're just a child, you could have trustees acting for years during that period. There's a lot for them to manage. You know, they have to deal with the returns, register the trust, which I've already spoken about. So it's very time consuming. And I would suggest that if you are appointing trustees, you definitely speak to them and obtain their consent before you do so.
Okay, yeah, fantastic. Thank you. So Peter, back on the tax side, and I think in your presentation, you talked about inheritance tax and the 7-year rule. Someone has asked whether or not you can make a gift into a trust without the 7-year rule applying.
Maybe you can. It could be the case that perhaps you gift an asset that's already excluded from inheritance tax into a trust. And we do see this from time to time. Perhaps somebody has shares in their own trading company and they gift those assets into a trust. And then you don't have to wait 7 years for the gift to then be excluded from UK inheritance tax. I think really the other option is that perhaps you're non-UK domiciled and you're giving an overseas asset into a trust, and then it's immediately exempt. It was never within the charge to inheritance tax. And then actually, you don't have to wait for those 7 years. So I think those are the two main circumstances I would think of where you can escape that 7-year clock winding down. Hugh, do you use a trust where you would actually, as an investment product, where you wouldn't have to wait 7 years to get the inheritance tax advantage?
I think both of those trusts that we discussed a little bit earlier on, Peter, which gave access to either income or capital, some of the benefits of both of those trusts accrue well, pretty much from day one. So if you remember a discounted gift trust, potentially the individual going into the trust gets a substantial discount against the value of the trust asset on day one. Loan trust, all of the growth on the trust asset also outside from day one. So in terms of both of those trusts, there's an element of the investment that is outside of scope from day one, but depends on the type of trust, I guess.
Okay, thanks Hugh and Peter. So then in terms of inheritance tax generally, Hugh, Ian has asked whether we can use life insurance to protect from inheritance tax.
Yes, that if particularly where we're looking at individuals who are making outright gifts. So as Peter has already outlined, if I make an outright gift to someone, then that's a pet, that's a potentially exempt transfer, and it's outside of my estate 7 years from the point at which I make it. If for whatever reason I don't make it 7 years, then in effect that pet has failed, and there's a potential inheritance tax liability on it if it's in excess of the nil rate. So potentially we might use life insurance to cover that 7-year period and to create some liquidity to pay a tax bill just in case that pet fails. That's very much a belt and braces approach, and making sure that we are making that potentially exempt transfer with zero risk to the person that's making the gift.
Okay, fantastic. So Shannon, a lot of people, so a really common question has been whether someone can be both trustee and beneficiary.
Yes, you can. There is no strict rule to say that you can't. You obviously have to be careful of a conflict of interest. That's the only thing. It would be perhaps better to appoint a third party that's impartial.
Okay, great, thank you. Peter, would you have anything to add to that in terms of people sort of playing both of those roles?
Yeah, and I think Shannon's really covered the major considerations there. I don't think there's really too much I would add from the tax point of view. I think perhaps the issues are around if you've gifted assets into a trust and you're saying that you no longer retain any kind of benefit or control over those assets, then I think an extra modicum of care is needed at that point, but nothing generally to add to what Shannon said there.
Okay, thanks. So Hugh, in your experience from a sort of financial planning one, what type of assets do you see people tend to put within a trust?
On the whole, the assets that we see going into trusts are liquid. So that can be anywhere from cash through bonds, shares, funds, those sorts of assets. They kind of lend themselves pretty well to trust planning, because if my asset is liquid, then I can make regular or ad hoc distributions out of the trust without any particular problems from an investment point of view. It's pretty difficult to chop a corner off a house and pay it to a beneficiary. So on the whole, trust assets liquid. You can put less liquid assets into a trust, but it's likely, as I said earlier, that you'd need a bespoke trust deed in order to do that. One other thing I would say is that another aspect that we look at is the kind of structuring of tax liabilities within a trust when we're kind of doing the financial planning around the trust itself. So a lot of the time we will try and employ a type of wrapper inside the trust or a type of investment platform that shelters the various parties to the trust from gains and income taxation ongoing and makes their life as simple as possible. I guess that comes back to sort of taking advice around structuring the investments within the trust correctly. But there are ways that we can make the life of your settlers and your trustees and your beneficiaries much easier from a tax point of view.
Brilliant. Thank you for that. And thank you, all of you. I think that's probably all we've really got time for today. I think from listening to you all speak, I think my main takeaways are that trust can be extremely versatile, and there's a host of reasons why someone might want to use one. But the key message seems to be that people need to take personalised advice to make the best use of those vehicles. So many of you listening today are probably very familiar with the Fry Group, but for those that aren't, I just wanted to give you a very short introduction. So the Fry Group was established more than 123 years ago, and since then we've helped thousands of people around our 8 offices in the world, giving them tax and financial planning advice from a global perspective. We offer 3 core areas of financial planning, being tax, estates, and investments. And our team work together across these areas and across the countries to find the right balance for our clients. Our core purpose is to make or to help people achieve their financial freedom. And we understand that this is going to mean a lot of different things to different people. And that is why at the Fry Group, we really take the time to understand what is important for you. If you would like to speak to anyone more about what you've heard today, then please take our contact details down or find them on the website. That just leaves me to say thank you everyone for joining us today. We really appreciate your feedback so that we can continue this webinar series. You'll shortly receive an email afterwards asking for your thoughts, and we look forward to receiving any comments that you have. Have a great day, everyone, and yeah, hope to speak to you soon.